Welcome. My name is Coriel Stevens, and welcome to the Judge Stevens Show. This is a special edition. Instead of our usual format, which you may know, of holding court cases in a courtroom and me making a decision afterward and then explaining the law, we're going to actually look at some real court cases, some of which that have been recently filed. Now keep in mind, please, this program is educational in nature. It is not to give legal advice. If anyone has a legal question or a legal issue, please consult with your own lawyer. The first case we're going to look at was written by our own President Judge Jack Piniella and joined in the decision by Judge Maria McLaughlin and me. The party bringing the appeal is called the appellant. The other party is called the appellee. In this case, the trial court granted the appellee's motion to suppress. That means that the appellee won at the trial level. And a motion to suppress means that certain evidence cannot be introduced at trial. So if, for example, it's a drug case and the information and the drugs cannot be introduced at trial, prosecution would not be able to prove beyond a reasonable doubt that there was drug use or drug sales. Now in this case, Pennsylvania State Troopers were patrolling on Interstate 80. They were traveling westbound and they observed a black Dodge Challenger weaving and swerving within its own lane. Suspecting that the driver was either texting or might be driving under the influence, the troopers followed it, and the SUV then did cross a fog line several times in violation of the vehicle code. The troopers waited 3 miles, followed it for 3 miles to an exit where they could safely stop the car. Now once they stopped the car, and the driver put the window down to give his license and registration, the troopers noticed immediately the smell of marijuana. That gave them probable cause to search the car, and they found marijuana, methamphetamines, knives, a digital scale, and they arrested the driver. The trial court granted the appellee's motion to suppress, meaning all that evidence could not be introduced at trial. And the reason was the driver of the car argued that the police had no reason to stop his car, therefore everything they found at the search was illegal. The Superior Court, our panel, we reversed the trial court and said the evidence should be admitted. And President Judge Piniella wrote, if a police officer possesses reasonable suspicion and can point to a specific and articulable facts which could lead him to reasonably suspect a violation of the vehicle code, he could stop the vehicle legally. And here, the troopers observed the vehicle weaving and crossing the fog line. Because they had reasonable suspicion to stop the vehicle, the evidence can proceed to a jury trial and the case can go on. So in that case, we reversed the trial court. Now I just want to mention the Superior Court is an intermediate appellate court, and we hear appeals from the trial court. We hear all criminal appeals and most civil appeals. Our sister court, the Commonwealth Court, has a more specialized duties hearing cases from administrative agencies and election matters. In Superior Court, no case is decided by one judge. 3 judges decide the case and 1 judge is assigned to write the case. We can affirm the trial court, which means that whatever happened there stays the same. We can reverse the trial court like we just did, which means an opposite conclusion, or we can remand the case, meaning we want more information. So we are assigned cases in panels of 3 judges, and each panel has 45 cases. The The second case is a civil case, doesn't involve the criminal law, authored by Judge Ann Lazarus and joined by Judge John Bender and Judge Gene Strasburger. In this case, the appellant worked for a company and he was assisting other employees, and they were using an overhead crane that had an excavation ripper on it. The excavation ripper detached from the chain hook and crushed the worker's leg. That required a below-the-knee amputation. So the worker's lawyer filed a lawsuit claiming that the product was defective and certain other things to get compensation for the worker. He sent the complaint, according to the law, by certified mail to the Tulsa, Oklahoma address of the company, which was the only office address the company had in the United States. The vice president of operations there said that they did not recognize the sender. So she put the unopened mail aside, never opened it, and the complaint was never answered. So pursuant to law, the workman's lawyer sent a notice after a certain number of days to the company again, saying, look, you didn't answer the complaint. We're going to take a default judgment against you in 10 days. And once again, the VP signed the return for the return receipt and again did not open the envelope. Judgment was entered against the company, and when the lawyers found out, they tried to set aside the judgment and have a trial. And the court said, look, you had a duty to respond, you didn't do it, and the case will remain the same. And we affirmed the trial court in that case. The next case coming up will be a criminal case, and it involves theft by unlawful taking and receiving stolen property, namely a dog.
The Judge Stevens Show is brought to you in part by Favello Law Firm. Injured? Call Favello Law Firm. Your case is our fight.
Welcome back. I am Corey L. Stevens, and this is a special edition of the Judge Stevens Show. In this next case, this criminal case, the decision was written by President Judge Emeritus John Bender and joined by Judge Mary Jane Bowes and former Judge John Cleland. In this case, the appellant is the founder and chief executive of a nonprofit organization called Dogs Deserve Better. And what they do is, when dogs are chained outside or out in a fenced area without anyone caring after them, they contact the owner and try to encourage them to take better care of the dog and take the dog in the house. They received several calls about a dog lying on the ground that needed medical attention at a residence. So the chief executive officer, the appellant, and one of her employees went to the house, and when no one answered the door, they took pictures of the dog lying on the ground to document it, and then they took the dog to a vet. And at the veterinarian, they met a humane officer. While the dog was being treated, the humane officer had to leave. So the appellant took the dog to her own home. And apparently the people who owned the dog called the police. When the police called the appellant and said, hey, you have their dog, take it back, she said no, the dog will die in their care. So she was arrested. And she admitted that she kept the dog. She posted it on social media, and she even did interviews with a local TV station, saying she took the dog. Now, her defense was there are certain defenses in the law, might be self-defense, there are various defenses. One of them is called justification, and it's very specific before you can kind of, be not responsible for what would normally be a criminal act, because if you comply with the law of justification. So the question in this case was, when an actor believes there is a harm, and a person is harmed, the question is a dog covered? And the court said, the trial court said no, and the Superior Court said no. When the justification defense is used, it's only available when the person who is in danger of harm is a person, not a dog. And the court pointed out the appellant had other legal alternatives, could offer to pay for medical expenses, could try to convince the couple, take better care of your dog, or could have filed a complaint. So that case was affirmed. The next case was written by me and joined by President Judge Piniella and a former judge, Pat Tamilia. This was a case where at 10:45 p.m., a police officer in a community on routine parole saw a car parked on a playground that you could only access through a gate, which meant that the car had to come through a grassy area. Upon investigation, the police officer saw that the engine was running, the appellant was asleep in the driver's seat, and the officer saw an open 40-ounce bottle of malt liquor in the car. He woke up appellant, who had glassy eyes and could not pass sobriety tests. So the appellant was arrested. The legal argument of the appellant was he was not operating the vehicle because he was asleep at the time. He did turn out, of course, I want to mention, he was found to be under the influence of alcohol beyond the legal limits, so he was charged with driving under the influence, DUI. The Superior Court held the sentence was affirmed. Actual physical control can be shown through circumstantial evidence. The officer doesn't have to see him driving the car. Here, the vehicle was parked in a highly inappropriate location. The engine was running. He was in the driver's seat. It was a gated area that he drove around the grass to get onto. All the circumstances together, the totality of the circumstances, confirmed the jury's finding of guilt. So that case we affirmed. In the next case, written by me and joined by President Judge Piniella and President Judge Emeritus John Bender, we looked at a burglary at an elementary school. After the alarm at the school went off, the business manager got to the school and chased out an intruder who got away from him. They had ransacked the teacher's lounge and several offices. Video surveillance showed that the appellant was sitting outside a window smoking a cigarette, and then inside the school they were able to identify the appellant from the video surveillance. He was convicted of burglary and related charges and sentenced to 2.5 to 10 years in jail. At the trial, he denied it was he on the video, claimed there were no fingerprints, and said any DNA on the cigarette was his mother's, who had a cigarette while she was dropping her grandchild off at the school. In this case, we affirmed the trial court and the jury's sentence of jail. The jury heard the evidence and made a finding of fact. So when there's a credibility issue, a believability issue, it's up to the jury as the fact finder to decide the facts. So in this case, the appellant said that was not him on the video, that was not him in the school. It was up to the jury to decide, did they believe him or not? They looked at the video and so on. On appeal to Superior Court, we do not substitute our judgment for the believability, credibility of any of the parties, because we do not see the witnesses on appeal, we do not hear them. When they are at the trial court, just like on a TV show, they are sworn in. The police officer, the appellant, they testify in court under oath, and the jury sees them and hears them. And then there's a court record made. Everything they say is written down, and that's what we look at on appeal. We don't see the police officer again, we don't see the appellant again. So if there's a credibility issue, the jury decides that, not the appellate court. This was a murder case, the next case, and it was decided by President Judge Jack Piniella, Judge Debbie Kunzelman, and Judge Kate Ford Elliott. In 2017, the appellant went to was at his residence, and he was trying to set up a drug transaction. When they waited for the buyer to arrive, the appellant wanted to know how much money he had. He said he had only $80, and the appellant wanted more. The appellant shot the buyer and pursued the car on foot as the guy drove away and shot him again, and he died. The matter proceeded to trial. Jury found the appellant guilty of murder, and he got life imprisonment. He tried to say there was not enough evidence to prove murder. And the court said to convict the defendant of first-degree murder, the Commonwealth must prove beyond a reasonable doubt that the defendant unlawfully killed another human being, acted with specific intent to kill, and the killing was willful, deliberate, and premeditated. And the specific intent can be inferred from the defendant's use of a weapon on a vital part of the victim's body. And in this case, that's exactly what happened. I do want to conclude by talking about some of the things the appellate court does. We interpret statutes, so if a statute says that the legislature passes a law, you cannot sell drugs if you sell drugs within 1,000 feet of a school, then you get a mandatory jail time of X amount of years. And in one case, the defendant tried to say, well, he didn't sell it at the front of the school building. He sold it at a track which was over a mile away. And we found that the intent of the legislature was to prevent drug sales where children are. Therefore, when they said school, they included school property. In the next segment, we will speak about some more cases and also the role of the appellate courts in the court system.
The Judge Stevens Show is brought to you in part by Favello Law Firm. Injured? Call Favello Law Firm. Your case is our fight.
Welcome back to another segment of the Judge Stevens Show. In this segment, I'm going to look at, in this case, it's a civil case in which the Superior Court, with President Judge Jack Piniella, Judge Vic Stabile, and myself, we upheld a verdict in a delayed cancer diagnosis death case. In this case, the executor of an estate wanted to have a new trial after a jury found in favor of the defendant doctor. Her estate was alleging that she died as a result not only of the cancer but of the delayed diagnosis. The trial court found that the delayed diagnosis, the jury found, that was not a factual cause of the death. And we affirmed that on appeal. And I want to mention what comes up in cases like this. It's called the battle of the experts. In a case that involves expert testimony, in this case it was doctors, one side presents a doctor that says X, and the other side presents a doctor that says Y. And both doctors are testifying to what they reasonably believe is the truth and the scientific method of whatever it is they're saying. And when this happens, a lot of times there's expert testimony on each side that conflicts with one another. That's why, as I said earlier, the jury is the fact finder, and they have to decide what is a fact. So if there's a car accident at an intersection and another car hits car one, and both sides claim the green light, the jury would have to decide which driver had the green light. That would be a fact. And the way they would do that is they would see were there any witnesses, was the traffic light operating properly? If it was the sun in the driver's eyes, or so on. And an accident reconstruction expert might come in and say, in my professional opinion, after reviewing all the documents in the accident scene, it's my opinion that car number one went through a red light. And then the other side, car number two, may have an expert that says, well, in my opinion, car number two had a green light. And that's why the jury has to look at the people, look at the evidence, and decide everything. Now, when we talk about evidence, I want to mention that in any court case, we deal with physical evidence and we deal with testimony, what people observed, what they heard, what you see, what you hear, what you smell, with your senses. Now, I just want to go back a minute. Experts can give their opinion based on their expertise. And to be an expert in Pennsylvania does not require a college degree. It's having special skill, knowledge, or training in an area that might be beyond what a normal person would have. So you don't, somebody that doesn't have a college degree may still be an expert in a trade, plumbing or some other trade, and then they would be able to testify. And then there's physical evidence, the evidence you could see and touch, and that can be shown to the jury. So in a serial killer case, a lot of the stuff that comes up is the physical evidence, the hair, the fibers, and so on. I want to mention, as I talk about the serial killer's cases, that the primary unit that investigates serial killers is the FBI Behavioral Analysis Unit. And there are a lot of TV shows about this. A lot of movies came out about serial killers since this unit was established. I had the opportunity to visit with that unit in a case when I was the district attorney. And what they do is they go through all the physical evidence, and then they come up with a profile of a serial killer. And then they use that profile to help the local police track down the serial killer. So I want to mention one of the famous cases, and that is a case that occurred. It was called the Atlanta murder cases. And in that case, young African American children were being murdered. So the Atlanta police called in the newly formed FBI unit, and they did a profile of it. And when they came up with the profile, some of the things that they came up with was that the person would be unemployed, that would have had knowledge of being involved as an investigator, and then they said the person was likely African American. Now that upset the Atlanta Police Department. They thought that that was a racial statement, an insensitive racial statement. But the FBI later, when they arrested the person, they were able to find him. He was a former police officer who happened to be African American. And they said it wasn't based because of any racial bias. It was based on the fact that whoever was doing it was operating in the African American neighborhoods very comfortably. It wasn't anybody that the children could point to or witnesses could point to and describe accurately. So the FBI was able to help solve that case. In another case of a serial killer in Alaska, there were murders going on of prostitutes, and they were having a difficult time solving those murders. So the local police called in the FBI unit, and they did a profile, and they felt that it was someone who had a physical disability. And through that, long and short of the case, they were able to track down, at the time, it was an individual who was well respected in the community, but he had a lisp in his voice. He had a disability in speaking. And they were able to use the FBI serial killer unit to discover them. So in Pennsylvania, I want to conclude by distinguishing, we've gone over some cases, the difference between the civil and the criminal cases. In a civil case, the burden of proof, what the person who brings the lawsuit is called the plaintiff, and the person being sued is called a defendant. And what the plaintiff has to prove to win their case in a civil case, it's called a preponderance of the evidence, which means that if there's an equal scale, if they prove it just a little bit in favor of one side, then they're entitled to win their case if the jury believes everything. In a criminal case, as you probably know, the burden of proof is called beyond a reasonable doubt. And that, the scales have to tip a lot more. So if you do serve on jury duty, you'll have the opportunity to hear these things from the trial judge, because if it's a civil case, they will explain what the law is. If it's a criminal case, they will explain what the law is. So the function of the jury then is to make the determination of the facts, and the judge explains the law to them, and then when they go in the jury room, they're the only ones there, and then they come up with a verdict. So I hope that you enjoyed this particular segment of of the Judge Stevens Show. Again, I want to thank SSP TV for carrying the Judge Stevens Show.
The Judge Stevens Show is brought to you in part by Favello Law Firm. Injured? Call Favello Law Firm. Your case is our fight.